Okay. So, good afternoon, everyone, and thank you so much for joining us today. We're excited to have, I think, over 300 people registered for this webinar. So people might be trickling in, but that's okay. We have a lot to cover. So we just want to get started. First of all, I just want to mention that David Nachman, unfortunately, is not going to be able to join the webinar. He had a last minute conflict that came up. And so you'll just have Ludka and I, but that's okay. Like I said, we have a lot to cover. I also want to take this time to thank our staff, Kunal and Rajesh, for helping us with this webinar today. And for those of you that don't know me, I am Snehal Batra, partner at NPZ Law Group. I'm in our Raritan, New Jersey office. I've been in practice since 2001. Primarily, my focus is business and family. And I have Ludka Zimovchak, my partner, with us on this webinar, and she's going to start us off in a moment about the H-1B process. But you know, these are some very stressful times for many of our clients. We're at the beginning of President Trump's second administration, and already we're seeing a lot of changes. Today, we're going to go over the H-1B non-immigrant visa, specifically about the upcoming lottery, the new modernization rules, compliance issues, because we expect to have an increased enforcement on some of these things under Trump 2.0. But with that being said, let me introduce you to Ludka, who's in our Ridgewood office, and she'll introduce herself, and then we'll get started. Ludka?
Thank you so much, Snell, for the introduction. So it's, of course, pleasure to have you here. As I said, I was just quickly looking at the names. I see a lot of our clients, a lot of students. So thank you very much. My name is Ludka Zimovchak. I am an immigration attorney. I've been practicing for over 20 years. Same as Snehal. I would say half of what I do is employment-based immigration, and half would be family-based immigration, different humanitarian cases, waivers, and so on. We have several offices. Obviously, Snehal mentioned Raritan. I'm in Ridgewood, New Jersey. We also just opened up office in Canada because that seems to be a big hit, Canadian immigration, and we also have office in Florida as well. But as you know, immigration is federal, so it doesn't really matter where we are. And I'm not gonna keep it this introduction much longer. Let's just get started. Very briefly, whoever heard us before, this is our favorite slide. But just to tell you where the H-1B is, because obviously we're going to be talking about H-1B only. So this is immigration law in snapshot. So when we have the HR or we have a student, who calls us telling us we have this employee who is great. He's on F1 and we would like him to become a citizen. Or the student would call, I really like it here. How do I become a citizen? So this is the chart where we used to explain how does the immigration law works? How do we move people from non-immigrant status to immigrant? And, obviously at the end, it would be citizenship. So we do have on the left-hand side column for no status. So these are people that either fell out of status. That can happen, to students, to people in visitor status, even H-1Bs, or people that entered without inspection. They have some options as well, and this is well beyond this seminar, but I just want you to know that even, people that don't have legal status or entered without inspection, they have their options as well. Then we have non-immigrants, and this is important. H-1B is a dual intent visa status. So it's a really strong, powerful type of visa because it allows for immigrant intent as well. So if somebody's thinking, or if you have an employee or you yourself want to apply for the green card, this is a perfect visa to have. So if you are, for example, a student working on an OPT, you may want to think about transferring to H-1B. Once you have the H-1B, you transfer to green card, whether it's a family-based green card or employment-based green card. And only then, after 5 years, you can apply for citizenship. You don't have to. I have to say, in the past 2-3 weeks, a lot of people are reaching out for citizenship. Those that have had green cards for really long time, 30 years, now they're thinking with the new administration to become citizens. But the only thing I want you to understand is that the H-1B is a dual intent. It's a really powerful, strong visa, and it's really great visa to have. I see already questions, but yes, if you have any questions, just put them in the chat. We're going to try to take them as we go. If not, we'll just leave it for the end. So what the H-1B is, since we have a really wide audience here, H-1B visa is a work visa. It's a temporary type of visa for professionals in specialty occupation. So those that are coming to work in specialty occupation. Number one, the applicant needs to have a bachelor's degree. Preferably, of course, that's the easiest, US bachelor's degree, but it could be a foreign degree as well, assuming that it's equivalent to the US bachelor's degree. Also, what we could use is education, for example, foreign education and experience. Again, we would have to do credentials evaluation. And I have to say very rare, but it's possible. We use 3-for-1 rule. So people having 12 years of experience, could be found equivalent to the US bachelor's degree. So it's 3 years of work experience can be substituted for 1 year of academic study. Very important, just because you have a degree doesn't mean that you qualify for the H-1B. It's really important that the position itself requires a bachelor's degree in specific field. So we've had people with master's degree even higher, being excited that they are going to be applying for the H-1B, but then the position is not a professional one. It's not even requiring a bachelor's degree. So this is really important. You have a degree, or the applicant has the degree, the position requires a degree, and then it also has to make sense as far as the company that they need services. Obviously, it needs to be some type of logical nexus between the three. So I keep referring to specialty occupation. What is that? What is the specialty occupation? So some obvious ones that, are easy, biologist, chemist, doctor, lawyer, accountant, graphic designers. There are just some occupations that are really easy. But of course, the question here is the bachelor's degree normally required for the position? So I have to say, and Snehal, I don't know if I'm talking for you as well, but I think, these typical positions, you just know off the top of your head. You don't really have to check, but there are many different occupations, and sometimes it's hard to pick which is the right one. So what we really do, if we are in doubt, we turn into Department of Labor, and we check different sources on Department of Labor's website. For example, we look at OOH. That's the one I go to right away. So it's an occupational outlook handbook. It doesn't have all the positions, but it has the major occupations. And they will state the minimum requirements. So for example, it will state a bachelor's degree in whatever field. So this is important, especially if you get requests for evidence, challenging specialty occupation. It's really good to look into OOH. Also own it. We also look at the SVP. Is it at least 7, 8, job zone 4? Then you're going to be fine. It's a professional occupation. Of course, if the company is doing a lot of H-1Bs, for example, or, it's a bigger organizations, we always look, what does the company normally require? Do they require a bachelor's degree in specific field? So that's important as well. And, lastly, we also look at newspaper for similar positions. What is the typical requirement in the industry for this type of position? So these are just some resources that we use when we are trying to determine whether or not the position is specialty and professional. We don't expect our clients or students, to be checking Department of Labor, but you can definitely look. You can look into ONET. You can even check out Occupational Outlook Handbook, so you have an idea for the minimum requirements for different positions. And they keep updating it all the time, so that's really important as well. There are some occupations that were professionals that suddenly are not. So I would recommend always double check. What is the issue with the H-1B? That we don't have enough of H-1Bs. That's the major problem with the H-1B. So there is a numerical limitation that we have on the H-1Bs, and that is 65,000 per year. We do have additional 20,000 H-1Bs for those with higher degree, U.S. master's degree or higher. So if you look at the slide, last year we've had about 470,000 H-1B registrations, and that number may seem really high, but 2 years ago it was over 800,000 registrations. So it's been really crazy. So it was definitely better, but I think we can expect similar number this year. Because of that, we do have a lottery. So, we don't have enough numbers. There is a random lottery. And we get this question all the time. Is this based on country? No, this is a green card. For H-1B, there is no country-based, it's all totally random. It doesn't matter what type of position. It doesn't matter what type of company. The only advantage there is for U.S. master's degree and higher, because they obviously get additional 20,000. So when there is a lottery, they're first doing lottery for the advanced level quota. And once they select people, then they concentrate on the regular cap. So that's the only advantage. For those that have higher U.S. master's degree and higher, will have a little bit better chance in a H-1B lottery. Who should be thinking about the H-1B and when it is a good idea? Some obvious would be probably F1s, so those that have OPT, optional practical training, and STEM. Obviously, these are great candidates. So in case you are the HR, you're thinking, who you should register for the H-1B, that would be a good idea. Also, students, those that are currently at school, you don't have to be on OPT. I got that question yesterday. So if you already have, like you're pursuing master's degree right now, and you have bachelor's degree and you have offer of employment, you could proceed with the H-1B. Or you may have a foreign education. So as long as it is equivalent to the US bachelor's degree, you can proceed with the H-1B. TNs, so our Canadians and our Mexican clients, if they're thinking about the green card, it would be a good idea to switch them to H-1B. TN is not a dual intent. And as I mentioned, H-1B is a dual intent visa. So again, if there is a future plan, a long-term plan to proceed with the green card, it would be a good idea to proceed with the H-1B. Of course, people outside of the US, you don't have to be in the United States to apply for the H-1B. So if, there is an applicant that you're thinking to bring to the United States for your company, or if we have a listener right now that is abroad, you could be abroad, again, as long as your degree is equivalent to the US bachelor's degree and you have offer of employment, you could proceed with the H-1B. Dependents, and that is very important. If you are in H-4, L2, or other dependent status, it would be a good idea to switch to H-1B. Why? Because if anything happens to the principal, to your spouse, your status will end as well. So in fact, I just spoke with somebody a few minutes ago, and he was just asking me about potentially, what's going to happen to his wife, because he may be losing the H-1B and the wife is on H-4 EAD. So obviously her H-4 would be out as well. So that would be a really good idea, since she's working right now, for the new employer to file an H-1B. L1s and L1Bs. So especially for our Indian clients, that would be a good idea, because it takes a long time, especially for L1Bs applying for perm for the green card. It's only 5 years. For L1A, it's only 7 years. So with the retrogression, it's important to switch over to H-1B from the L. And then lastly, we have all kinds of humanitarian programs. And this has been, I have to say, there is not a day where I don't get question about TPS and DACA. We just heard about TPS for Venezuela that is going to be ending. So, it's in case by case. Obviously, the analysis has to be done. TPS could be changed to H-1B. So our DACians, while the change of status is not possible, but there is a possibility to do consular processing. So I would really look into those holding DACA and TPS if there is a potential doing the H-1B, especially now with the new administration. We don't know what the future holds for TPS for other countries and for our DACians. And obviously, those that in the past been in the H-1B lottery, they can try again. There is no limit. So, we have people that been in a lottery 3 times and still not successful. So you never know. It's important to try. So let's talk about the H-1B, because it's coming up. It's very exciting. We are all preparing for the H-1B registration. USCIS just announced that the H-1B registration will start at noontime on March 7, and it will run until March 24th, noon again. It doesn't really matter if you do H-1B registration filing on first day, in the middle, even the last day, even though I would be cautious on filing the last day, because just in case you have some technical difficulties, you don't want to stress and file it the last day. But you're not going to have better option or better chance in a lottery if you file it the first day. So anytime between March 7 and March 24th, it will be fine. So I believe this is going to be 4th or 5th year, I cannot remember, of the H-1B registration. In the past, we had to do actual filing on April 1st. So we're kind of lucky that we have this H-1B registration process. Just to clarify, it's the company, it's the organization or attorney doing the H-1B registration, not the applicant, not the beneficiary. It needs to be done online. So for those that have never done, the companies that have never done the H-1B registration, you can create your online account, the organizational account. Now you don't have to wait until March 7. For those of you that haven't done H-1B last year, but you might have done H-1B registration 2 years ago, 3 years ago, if you sign in now into your USCIS online account, your account will be automatically transferred into the new organizational account that was created last year. And obviously, for those that have been doing H-1B registration last year, there is no change. The fee is higher. We knew that. That was established last year, $215, even though last year they still honored the $10. So it's a significant jump to $215 for each beneficiary. So once the H-1B registration is done, the lottery will be done prior to March the 31st. So we should know by March 31st who was selected. Only those that were selected will be notified through online accounts. And again, only those that were selected will be able to file the H-1B starting on April 1st, and it will run till June 30th. So you can file it at any time. The only little note here I would like to point out that if you have the beneficiary, or if you are the beneficiary graduating, and for example, you're using the advanced level, the master's level, you need to wait. You don't want to file right away in April. You need to wait until you graduate and only file after the graduation. This is really important. So just to recap the dates, Now in March 7, we have the registration. Whoever is selected, the petitioner can file the H-1B starting on April 1st. Start date for the H-1B is October 1st, not earlier. And this is really important. Why? Because you need to ensure that you maintain legal status if you're in the United States until October 1st. For F1 students, it's pretty simple, especially those on OPT, because they can use Cap-exempt. And assuming the H-1B is approved automatically on October 1st, the H-1B, the person's status will change automatically from F1 to H-1B. If the H-1B is still pending, good news, and I know Snehal will be talking about it, this was extended with the new rule until April 1st. So the cap, would be extended till April 1st. So this is some good news. But for all other statuses, you have to ensure that you have and you are maintaining legal status till October 1st. So for J's, for H4s, and all other visa holders. So H-1B final rule. In 2023, in October, there was a notice of proposed rulemaking in Federal Register. We've been all waiting. There were comments. We've been waiting for the H-1B final rule. And ultimately, last year, around this time, was I think February, we got a partial final rule as it relates to registration. And that explains why from 2 years ago, we went down from 800,000 H-1B registrations to around 470,000 registrations. So with the partial final rule that took place last year, the government introduced beneficiary-centric selection process just to avoid fraud and have equal opportunity. What does that mean? Well, it means that they're counting the beneficiary and not registrations. So what was happening before, there were beneficiaries that had 10 different companies doing H-1B registration just to increase their chance in a lottery. So now it doesn't really matter if the beneficiary has 5 or 10 different companies doing the H-1B registration because it will be only beneficiary who is selected. So it's a unique to beneficiary. Also, with that partial final rule, there was established a start date flexibility, so it doesn't have to be October 1st. If there is a need to start on December 1st, that is fine as well. And lastly, if you remember last year, there was a lot of confusion with the fees because we also got new fees. And it's still the same. So for bigger organizations over 25, it's 780, smaller, 460. We still have the fraud fee, $500, and training fee, $750 and $1,500. But I think what was the most confusing was asylum program fee, and there were a lot of rejections. So smaller companies have to pay $300, bigger companies $600, and nonprofits don't have to pay. A lot of clients are very confused, and they think we are confused that they're not applying for asylum. But it is an asylum program fee that was established to fund asylum applications. So it's not just for the H-1Bs, but for other petitions as well. And on top, of course, premium processing was increased. So we still have the same fee for H-1B. It's $2,805. Online filings are available as of last year. And as of January 17, because of the new final rule, the second part of the final rule was announced in December. It became effective on January 17. We have the new I-129 form. So if you're not doing an online H-1B, just make sure that you use the right edition. Otherwise, your H-1B will be rejected. And let's go to the second part of the final rule. And, we have some major changes here. And I'm going to let Snehal talk about some changes that, obviously this just happened a few weeks ago. Snehal, so what are the major changes with that new H-1B final rule, especially the second part of it.
Right, right. Thank you. Um, okay, so as Luca mentioned, this is the new rule that is now in effect, excuse me, as of January 17th. And it makes some important modifications to the H-1B program. In addition, it modifies a lot of things related to that I-129, but specifically, I'm going to talk about those things that impact our H-1B employers. One of the first things it does is that it revises the definition and criteria for specialty occupation. It clarifies that that an employer normally requiring a bachelor's degree doesn't have to mean that the employer always must require a bachelor's degree. You can also require a range of qualifying degrees. So that's something new, but there has to be a direct relationship between the degree and the duties of the position. Um, the new rule also codifies the deference policy that when officers are adjudicating petitions that involve the same parties, the same underlying facts, that they generally should defer to their prior decisions on eligibility, unless, of course, there's a material error in the previous approval or a material change. So I think that we can expect to see some RFEs, even though the deference policy is codified in this new rule. The final modernization rule also modestly expands the certain H-1B cap exemptions. It allows for cap exemption even if research or education is not the organization's primary activity or mission, as long as it's one of the organization's fundamental activities. So I think that this should allow some other potential employers to fit into this cap exempt, which is great because there are not enough visa numbers, as we know. And it's one of the things that we do when we meet with a potential new employer to see, what exactly is your company doing? Are you affiliated with the university? Because they may not even be aware that there might be a way to qualify as a cap exempt. The other thing with this modernization rule is that it allows a cap exempt when the H-1B employee is not directly employed by the qualifying organization, but still spends half their time as opposed to a majority of the time under the previous regulation. And also now, the nice thing is that the employee doesn't have to spend, the definition says at a qualifying institution, but it actually means that they can perform work remotely too. So that's also a nice thing. One of the bigger changes that I think it will open up some doors for some potential clients is that the modernization rule now codifies that entrepreneurs can apply for H-1B status through their own startups, if they own, let's say, 51%. It does allow them to do some non-professional, non-specialty H-1B level work, as long as, majority of the activities are related to the specialty occupation. The one thing regarding this rule is that the Immigration Service is going to limit the approval to 18 months and then potentially another 18-month extension. Now the immigration, or DHS, I should say, is codifying the immigration's authority to conduct site visits. And it also says that if an employer refuses to comply with the site visit, it could result in a denial or revocation of the petition. So this is right here in this new rule, and we're going to talk a little bit more about compliance issues because I think we're going to see some, obviously, more enforcement under the Trump administration. One big change is regarding our F1 students and the cap gap protections. So the rule says that now the cap gap protection period is extended all the way to from October 1 to April 1 of the following year. So those people that are waiting for a change of status, it's going to help them so that they don't, their employment authorization doesn't lapse. They can continue to stay in status and wait until the H-1B is adjudicated. This is great because unfortunately, without premium processing, immigration takes a long time. And so this will allow students some additional time to continue employment. Next slide, please. Thank you. So H-1Bs are initially approved for 3 years, and then they can be extended for an additional 3 years, so a total of 6 years. Any time that you spend outside the US, whether you go on vacation or business trips, that's not counted towards the H-1B period. And we can recapture some of this unused time. So for example, if you took a 2-week vacation every year, plus you maybe have 30 days of business travel, well, we can recapture some of this time when we file for an extension. And this becomes important for our foreign nationals who are approaching their 6-year max out date, because they need additional time, maybe because their green card application is still in process. So it's important to be able to recapture unused H-1B time. There's also some rules related to extending your H-1B beyond 6 years, and these fall under the AC-21 rules. So you're able to extend your H-1B for 1 year if your labor certification or I-140 was filed at least 365 days before your H-1B expired. You also can get a 3-year extension of your H-1B if you have an approved I-140 and can adjust your status because of per country limitations and backlogs. And you also can request multiple extensions for 3-year increments. This is significant, and a lot of our clients from India, let's say, have been waiting for a long time to file for an adjustment of status. So AC-21 allows them to continue to work under H-1B beyond 6 years. And the other thing to know is that you also don't have to be in H-1 status, and it could be based on a different employer that filed your I-140. So that's good to know. Great. So H-1Bs are employer specific. This means you can only work for your H-1B employer. However, you can work for multiple employers, and this is what we call concurrent employment. So let's say your H-1B is approved for company A and you want to take on a second job. So company B would file a concurrent H-1B. They don't have to go through the lottery since you're already counted against the H-1B cap. But the second job also needs to be an H-1B professional position. H-1Bs are also portable. What that means is that the H-1B employee is authorized to start working for the new employer as soon as that H-1B transfer application is filed, even without a decision. And then while that decision is still pending, the employee is in a period of authorized stay. And when you're counted towards the cap, you have to be in lawful status and you can't be employed without authorization. The benefit of this portability provision is that it allows H-1B employees to change to a different job without being out of status. And of course, the employer can start utilizing the H-1B employee right away. And the other thing is about part-time employment. Most people aren't aware that you can be on an H-1B in a part-time position. There's no requirement that the position be full-time. But anything less than 35 hours is considered part-time. And there's also no minimum number of hours to qualify for part-time. So you can have even a range, of part-time work. That's not a problem.
It's now we get a lot of questions on this. It's again
Mhm.
every single day on a part-time. It's not a problem at all. We
Right.
have H-1Bs for 5 hours per week. So it's, and oftentimes we do that with concurrent H-1B. And we are going to get to it when we talk about cap-exempt H-1Bs. So it's really not a problem.
Right. So cap exempt.
Here we go.
So certain filings are not subject to the H-1B cap. extensions, and transfers. That means you already have been counted towards the cap, so you don't have to worry about going back in the lottery. So when you file your extension or change your employer, it's done without any issues. Then there are also cap-exempt employers. This means that they can file your H-1B at any time of the year. They don't have to wait until this upcoming March to enter the lottery and then file the H-1B. And these are institutions of higher education, nonprofit colleges and universities, nonprofit organizations like teaching hospitals, or other nonprofit entities that are associated with or affiliated with institutions of higher education. Even governmental organizations that do research, federal, state, or local entities could be cap exempt. Now, under the new modernization rule, as I mentioned earlier, there's more flexibility. So hopefully some more institutions, would be able to qualify for cap exempt. Now, keep in mind though, and this is the thing that I think most people may be not aware of, is that if you're working for a cap exempt employer, then no problem with taking on a concurrent position with a cap subject employer, so a private employer. You can do that without going into the lottery. But you have to keep your cap exempt H-1B active and you have to continue to work for that employer. Because once you stop working, you no longer can work for that cap subject employer. That also goes away with. So really, really important that if you are working for a cap exempt employer, no problem with working for a private entity, but you have to make sure that you continue that cap exempt H-1B. So that's something to definitely be aware of, because otherwise now you are going to be subject to the cap and now you're going to have to wait until the following year to enter the lottery. So sometimes it's helpful to have a cap exempt employer on a part-time basis, as Luca said, maybe as little as 5 hours, and then also pick up a cap subject employer, which you're able to do as long as you keep that cap exempt H-1B active. So sometimes that could be a workaround, a strategy if you have no other options left or you're on your final year of your STEM EAD and you're running out of ways to continue employment and stay in the US. Okay. So I'm going to talk now about the compliance aspect of the H-1B, because the H-1B program requires the employer to file a labor condition application, which is different than the labor certification. The employer has to accurately specify employer information, the number of workers, classification, location, wage, all of these things on this labor condition application that gets filed online with the Department of Labor. Now, this has to be done before you file your H-1B because you need the certified LCA to file your H-1B petition. So it's a really, really important aspect to this H-1B filing. It's part of the compliance requirement for H-1B employers. The employer promises as part of this LCA process that they're going to pay the required wage, which is the higher of the prevailing wage or the actual wage for this position, that the employer is going to provide working conditions that will not adversely affect similarly employed workers in the US, that there's no strike or lockout at the work site. And this is an ongoing obligation for the employer during the LCA period. The employer also has to provide a notice of the LCA to the bargaining representative. If there's a collective bargaining agreement, for example, if there's a union job, or the employer has to post a notice of the LCA on their work site and has to provide the H-1B beneficiary the certified LCA prior to the employee starting employment. Now, the LCA also has to be made available for public inspection within 1 day of filing. So that's part of this public access file that we're going to go over next. maybe after this slide. But the other thing that I want to mention is there are some obligations. So as we get closer to the H-1B lottery, employers should understand that they have obligations when hiring an H-1B employee. So first of all, the employer has to pay the required wage. We get this question all the time, like, what is the wage we have to pay, right? So as I said, you have to pay the higher of the prevailing wage or actual wage, but the employer also has to pay for all non-productive time that's caused by anything related to the conditions of employment, lack of work, maybe the employee doesn't have a permit, right? Or maybe the employee requires training. All of this non-productive time still has to be paid. You can't bench an employee because there's no work for that employee. You have to pay them. Um, the employer doesn't have to pay, however, for anything unrelated to employment, like if the H-1B takes a voluntary leave of absence, right, for illness or even for pleasure, and it has to be truly voluntary. Um, the employer's obligation only stops when there's been a bona fide termination, right? And so what does that mean? That means that the employer has to notify the H-1B worker that the employer-employee relationship is terminated. And the employer has to notify USCIS so that they can be made aware. And so the employer doesn't have this continuing obligation to pay wages. The other big thing to know is that when the employer terminates, the foreign national, they have to pay for the return transportation back home. Typically, this is not a problem because in most cases, the H-1B foreign national, what they're going to do is they have a 60-day grace period if they are terminated, and they will usually transfer that H-1B to another employer. And the other thing related to the employer obligation is that if there are any material changes in the H-1B, then the employer needs to file an H-1B amendment. Material change could be anything like a change in work location, if you go from part-time to full-time, if the salary drops below the prevailing wage. So these are things that would require amending the H-1B. And the employer also has to update the public access file if there is any type of corporate restructuring or change. And I think the next slide is the public access file, right? So the LCA is attestation based. That means that the employer is going to is promising to the government, but doesn't submit any documents. They have to keep this documentation in what we call a public access file. And the LCA also establishes an enforcement system to make sure that the employer is complying with these requirements. So they have to make this documentation available within 1 day of filing that LCA. And there are some very specific items that the employer has to keep in this path. We have the list here. You have to keep the certified and signed LCA, a memo that states the wage rate for the employee and what the system is for calculating this. They also have to keep the prevailing wage source documentation, also evidence that the employer complied with the posting and notice requirement of the LCA. They also have to include a summary of benefits that they're providing or offering to the H-1B foreign national. And there are some very specific requirements for those employers that are heavily dependent on H-1B workforce. So we're not going to cover that here, but that documentation also needs to be part of the public access file. And of course, if you have some corporate restructuring, then you need to make reference to that in the public access file, that the successor and interest employer is going to take over the responsibilities of the LCA.
And I
And
just want to stress that path is so important, especially, I mean, it's always been important, but you were
yeah,
talking about site visits, and, that's probably the expectation that we have with the new
right.
administration. So it is crucial not only to have it, but, to make sure that the company, when somebody comes, that they know where the documents are, where the path is, and what's going on. So it's really important to have somebody who is aware of where this public access folder is, whether it's online, whether it's hard copy, but very, very important.
Right. They have to be, so the path needs to be kept at the principal place of business of the employer or at the work site. And they have to keep the path for 1 year after the last day of employment. And they can also be stored electronically or a hard copy. And, most people, don't realize that this is not part of their HR file. So it's really important not to mix the the H-1B individual's HR documentation with this file, because it's not part of that. Because if you do include documents in there, then now what happens is if there is a site visit or an audit, all of this now becomes part of the public record. And so just keep this path folder separately, because you don't want to compromise any sensitive information and of course the employee's privacy. Next slide, please. Because this is such an integral part of this process, part of what we do when we do an H-1B is that we provide a full path to the employer with instructions on what they need to do and keep this in the event of an audit. But you'd be surprised that many employers, as Ludka mentioned too, they don't maintain this or it's not maintained properly. And that's where we're going to run into problems now under this administration, because failure to maintain the path can result in civil penalties, maybe even back wage orders, and perhaps even debarment from the H-1B program. And keep in mind that under this administration, we're definitely going to see some more enforcement, but sometimes audits result from disgruntled employees, right? So if they file a complaint with the Department of Labor, it could be from an H-1B employee, even a US worker, maybe that was terminated and can't find another job. So we have no way of knowing, what caused the Department of Labor to come in and ask for the public access file, but it's really important that you maintain this. We've helped a lot of clients over the years when the Department of Labor does come in and conducts an audit, and you don't have a lot of time. So if you have, a number of H-1B foreign nationals, it is important that all of this information and documentation be done properly in the event you need to present this. Okay, let me just see how much time. Okay. I know we have a lot of questions here, so I'm just going to go through like the last couple of compliance stuff real quick. But as I said, under this administration, we can anticipate that there's going to be also an increased focus on I-9 employment eligibility verification. And so it is really important that you have I-9 for every employee. There is a new form that was published August 1st of 2023. And most importantly, you have to remember as an employer, for some of these categories, you have to re-verify employment authorization. For example, when an individual's H-1B expires, or if somebody is porting, right? If you are hiring somebody for the first time and they are in this transition phase where they are no longer with their employer, or they're working for them and they want to work for you. So you're porting them. So you need to make sure that you have appropriate documentation that the individual is still in status, that you can timely file the transfer. And all of this needs to be referenced on Supplement B of the I-9. Same thing for students that are going to be protected under Cap-exempt. You have to re-verify that they were selected in the lottery and reference Cap-exempt on their I-9. So make sure that your HR folks that are responsible for the I-9, that they go back to check, because this is where I think they're going to be targeting compliance issues for worksite visits and enforcements. So just make sure you're on top of that. And again, we can help with that too. David Nachman, our partner, he handles a lot of I-9 investigations and compliance issues. He
And
typically
I
covers this.
And
Um,
also, I'm not sure if you mentioned Department of State. So I've seen lately checks from Department of State. So once H-1B petition is approved, several of our clients received emails from Department of
yeah,
State, double checking the job title. There has to be response, emailed regarding the place of employment. They're just verifying all the information. So you need to watch out for that as well. Um,
right. You know, we don't really go into it here, but what I want to mention is that if the, if anybody comes to your place of business and they say they're from the Department of Labor and that they're going to do a site investigation, make sure that the people that you have there, your employees, that they know what to say. If you are not there and you want to be there, they can certainly say that, owner is not here, my HR individual is not here, give me your card. We'll have them call you, contact us if you need our assistance. So make sure that you communicate with your staff so that when somebody does come in, they're not given, free range of go ahead and do the investigation and here are all the documents. So it is important, especially now with these ICE visits and warrants. Is it a administrative warrant? Is it a criminal warrant? So make sure the right people are there. Um, Okay, so I think now we are at the end, almost at the end of the seminar, but a couple of things to keep in mind for this H-1B upcoming registration period is that really important to get all the information up front from the individual so that we can do an analysis to make sure that they qualify for the H-1B. We have all the relevant information, especially for employer credentials, logins. Does the individual fall under the master's cap? Does the school qualify? We can also anticipate that we're going to be getting RFEs from the Immigration Service. As Lutka mentioned, we're already seeing it
We hear it
under
from our
the,
colleagues as well, that
yes,
there are extensive requests for evidence, especially for specialty occupation.
right,
So I think this is something that's going to happen this season because we already see it. So it's really important to have your specialty occupation arguments tight.
ready.
Yeah, I mean, we've dealt with it during the Trump's administration
First
before.
administration, right,
So, we can always overcome it, but it's better to be prepared, as I mentioned, regarding the OOH and ONED. It's really important to do analysis in advance and just have the alternatives ready. This is,
right. So Lutka, you want to just quickly go over
yeah,
that? I
just
think
yeah,
that's our last
it's
slide.
really, really important. Everyone concentrates on the H-1B, but with the lottery and it's so random, uh, you need to have your backup options. And it's too late on March 31st to start thinking about E2 or other options. So obviously, if you're in F1 status, you are an OPT, for example. Make sure that you speak to different schools, potentially go and do your master's degree or PhD. So, that could be plan number one. There are different type of visas based on treaty. So it depends what kind of passport you hold. If you are, we talked about TN. If you're Canadian or Mexican, you always have TN. All of these visas as alternatives, they don't have any limitations, numerical limitations, or any deadlines. If you are thinking, and I see a lot of questions, and we're going to be taking these questions, asking about starting the business. Well, if you are from one of the 3D country that you can easily check E2 um, 3D countries, you're going to get list of countries that qualify for the E2. You may start thinking about the E2. You can be self-employed. You can either buy a business, you can create a business from scratch. You have to do an investment. And if you ask me how much money, there is no specific amount. It's a substantial amount based on the type of a business. So could be 80,000, could be 100,000. It just depends on the type of a business. If you have a great credentials, then maybe H-1B is not even for you. You may be thinking about the O1. O1A is for somebody of extraordinary ability. O1B is for artist. We refer to it as an artist visa. If you're from Australia, we would be thinking of E3 immediately. It's very similar to H-1B, but it's not a dual intent. If you are from Chile or Singapore, it would be H-1B1. It is like H-1B, but again, not a dual intent. There is a numerical limitation, but it's never been reached, so you can just apply at any time. We do have, and we have some questions here about the J. It's a good visa. It's not the best. It's not a dual intent. So H-1B is definitely better. There are different types of J1s, which you have to be careful about to make sure you would not be subject to the 2-year residency requirement, because then you would not be able to obtain a green card or later switch to H-1B. P visa. So if you are a professional athlete, so you may be studying, but maybe you are also playing professionally tennis. P1 is a great option. P3 is for activities that are culturally unique. So again, if on the side you're doing some type of dance that is culturally unique and you have a company you would like to coach or teach, that may be an option. So it's really important to understand that there are many different options, not just H-1B. And even that Snehal, you were talking about the Cap-exempt H-1B. That is important to explore it beforehand. Some cases, somebody was asking me about nonprofit, whether, nonprofit can do the H-1B if they're not affiliated with university. Well, if you do some type of research, we just talked about the new rule, you may qualify under Cap-exempt organization. But since we are now in a H-1B season, maybe it wouldn't be a bad idea to try the lottery. If that doesn't work out, then make an argument for Cap-exempt H-1B. What other options do we have here? So these are just some, we have iVisa, media, but, it's really important to explore it and not just be thinking about the H-1B. Anything else I forgot, Snehal, for the option?
No, I mean, this is the whole
Yeah. So
ABCs of
I really
non-immigrants.
want to get to questions because you guys have really great questions. So let's probably just go into it. Okay, I'm gonna start with this one. I'm on a F1 expiring on OPT is expiring on June 30th. Would I be able to remain in the US? Well, if you were selected and filed the H-1B, you're going to benefit from the cap extension. So not only you can remain in the United States, but you can work in the United States. If you don't have a decision, if you file with regular processing, now, because of the change, you can even go beyond October because cap extension will be extended until April 1st.
I
Okay.
just realized that I was responding to some questions, but not for everybody. So, yeah.
Yeah.
Um, so I have a question here. Can we file for H-1B if the employee is part-time and works in marketing? So two separate questions, but of course, part-time employment is fine and works in marketing. So that's going to depend on the position. What is the position? And does it typically require a bachelor's degree, as we mentioned? So it's possible, but we would have to see what are your job duties?
And with the specialty occupation, sometimes there is some creativity. I'm not sure if it was that question. There were several questions about different majors. So, for example, you may have one major, but then you have experience in a different field. What we could do, depending on what the position is, what we could do is evaluation and combine the experience and see what we get. What's critical is that we can show closely relation and nexus between your job duties and the major. So, you may have a master's degree, but sometimes we may use your bachelor's degree because it's going to relate more to the position. It's just
Yeah.
really important to show that connection.
There's a question here. How about advanced master's degree from non-US universities for overseas students? So yeah, so non-US master's degrees are not going to work for the cap exempt, if that was the question, for that 20,000 master's cap visa. It has to be a US university and it has to be nonprofit or public. So that's something that, we would have to check. So question here is if the employee gets approved in the lottery, does that guarantee their full application will be approved? No, it does not. So if your case is selected in the lottery, your registration is selected, the employer files the H-1B application. It doesn't guarantee that will be approved. It just means that now you have the ability to file. So they're going to do the same analysis, do you meet the specialty occupation, wage, and just so on and so forth. So there's no guarantee.
Another question, and there were several questions just like that. If I'm working on the H-1B, can I work on a side hustle, or, have my solo business? So you need a concurrent H-1B. So Snell was explaining how H-1B is tied to the employer. So anything else you're going to be doing, you need a concurrent. So you need second H-1B. So potentially, if you're creating a startup and it's not just you, there are a few more people, you could potentially do it. But you need concurrent H-1B because otherwise you would be violating the H-1B.
Yes. So another good question is, do those with a master's get only opportunity for the 20,000 or do they also get a chance? So this is a great question. So if you're going to file under the master's cap, right? So there's no real option, but when you put in this information, right, it'll be selected first in the master's cap. If you don't get selected, what happens is your registration is put back into the regular pool of registrations and you have a potential second opportunity to get selected. So there is certainly an advantage to file under the master's cap. Okay, there's a couple of questions here about Australian citizens and E2 and E3. So those are really outside the scope of what we're doing here, but I do want to mention that that is an option, E3, which is similar to an H-1B for Australian. So feel free to reach out to us if you have anything specific on that.
There were several questions about academic H-1Bs. Also, I see I have a J1, I'm a research scholar and applying for teaching positions. They're going to be all cap-exempt H-1Bs, so there are no numerical limitations and no deadlines. So the organization will be able to file H-1B at any time. If the start date is September, any time can be filed. So you don't have to worry about March registration. Again, colleges, universities, nonprofits that are affiliated with the universities or nonprofits that are doing research, they're cap exempt and they can do H-1B at any time. You don't have to do H-1B registration. And yes, we do see H-1Bs for postdocs.
Okay.
What are some visas to consider that don't require employers or employment? It's a very vague question. It's a very vague question. It would just depend what activity. Religious workers have R1. There has to be some type of activity. Otherwise, it would be a visitor visa.
Okay, how often can an employer apply for H-1B for their employee? If they are cap exempt, can they apply multiple times in a year? Okay, so I think those are two like different questions, but an employer can apply as many times as they want for that individual. And the other thing to know is that you don't have to be in the US. The potential H-1B candidate doesn't have to be physically in the US for the employer to file for that person. They could be a foreign national working in their home country, and if an employer wants to sponsor you, they can. And they can do that as many times as the offer is extended to you until you get selected. If the second part of this question is if they are cap exempt, can they apply multiple times in a year if the first one fails? Yes. If you are cap exempt, I think the question is if you're cap exempt and your H-1B is not approved, can you apply again? You can, and that applies for anything. If your application is denied, you can refile, assuming that you can overcome what the issue is.
For part-time employee, they can be working 5 hours, as Snehal mentioned. How do we know what is the required salary and how do we determine? Okay, so when we look at the prevailing wage, that is as a yearly salary or it could be hourly. So if it's 5 hours, we're just gonna put hourly salary. So if it's $35 per hour, that's what it is. Very simple. So it would be hourly.
Okay, question here is I want to move from one cap exempt job to another H-1B transfer. Will it restart my 3 + 3 years time? No. So when you get selected in the H-1B lottery and you get approved, now you're starting your H-1B stay. That H-1B stay is yours, meaning that whether you work for a different company, you transfer that, it's any time that you are in H-1B status, that's counted towards that maximum 6-year period. But when an employer is filing a transfer for you at that time, they can request a 3-year approval period.
So pretty much
Assuming you have that time left.
whether it's a cap exempt or it's normal lottery H-1B, it still counts towards the H-1B. Bottom line is you only have 6 years. That's it. Whether it's a cap exempt or it's not, you only have 6 years of H-1B. If you spend any time outside of the US, that you can deduct. But other than that, you're not getting new 6 year just because now you're going through the lottery.
Right. Question here is if your company has reduced your full-time hours per week, does that affect anything? Absolutely. If you are fall below 35 hours, that's considered part-time according to the Department of Labor. And now your employer has to file a new LCA, which now requires them to file an H-1B amendment.
Okay, this is a good question. If I'm DACA, living in the United States, and I'm working, can this lottery benefit me? Yeah, but there would have to be analysis done. So H-1B can be filed, H-1B lottery can be done, not a problem. The problem is gonna be that you have to get your H-1B abroad through consular processing. And what we would have to know is if you have any type of unlawful presence in the United States, because if you do, you're going to need non-immigrant waiver. If you don't, you can just pick up the H-1B abroad. So there would have to be analysis. You would have to provide all the details and see, what it is. But yeah, definitely. As I mentioned, for our DACIans, whenever we can, we try to move them to H-1B because we don't know what the future will be of the H-1B. Even though I have to say, President Trump did say that he, in the past wanted to end the DACA. Now he said that he's all for DACIans and wants to help them. So let's see.
Yeah. Can you pursue another degree while in H-1B? You can, however, that cannot be your primary purpose in the US. So if you're taking part-time classes, that's not a problem. Another question here is, does the sponsoring business have to demonstrate financial capability to hire somebody? And if yes, how so? So for H-1B, the employer doesn't need to demonstrate financial ability to pay, but they have to agree to pay what the salary is, right? Prevailing wage or actual wage. So they have to pay you that. So that is not something they have to provide proof or evidence, but they will have to pay you that. A lot of times people get confused with the PERM labor certification and I-140, where for that there is a very specific requirement on employers' ability to pay the prevailing wage. Okay, it's assumed that the employer can pay this, but they don't have to provide any financial evidence.
Can I apply to a job related to my bachelor's degree despite just finishing my master's degree in different field? Yes, absolutely. That's what I was saying before. that, yeah, if your new offered position relates to bachelor's, you can use that for the H-1B. But I would still do master's level for the H-1B lottery, of course. Mm. Is there any advantage to apply as PhD versus master's? Not really. For the purposes of the H-1B, not really. For the purposes of the green card, yes. You know, PhD obviously is higher. So maybe if you do some research, you publish papers, you're going to qualify for more categories for the green card. But as far as the H-1B, no. With PhD, you're going to fall under advanced level, same as master's.
I also want to mention that we do have a newsletter, so please, we should have your email, but if you are interested in receiving our newsletter, which provides, current up-to-date information on all of these things, please reach out to us and let us know, and then we can add you to our email list because we are going to be running out of time here.
Yeah, this is a good question, Snahal. For the advanced degrees, a master's degree, the 20,000 cap, is it possible to know the universities, that will qualify? Yeah, we did not mention it. So not every US master's degree will qualify for that 20,000. So if it's a public, it's not a problem at all. But if it's a for-profit, private, that's going to be a problem.
But it could be a private, not-for-profit. So what
Right.
happens is what we do is that when we have our intake, we request this information and then we, check online. Unfortunately, I'm not aware of any list that's maintained by, that's out there in the public that says yes or no for every school, but it's pretty easy to find out. You just look up the school and then they'll have some information about the university.
So for our beneficiaries that are owners of the companies, what are the requirements for the H-1B? So it's the same requirement as regular H-1B. If you are owner, you can spend some percentage of time managing your business, but then, the majority needs to relate to that specialty occupation that we are arguing. Snehal mentioned that it will be only valid for 18 months. But it's really important, especially if it's a startup, that you have all the documents ready, lease, all the corporate documents, showing that the business is already running and there is availability of work.
Right.
By concurrent H-1B, is it like a sub visa or do I need to reapply if I'm applying for the... Okay, so concurrent H-1B is a second H-1B. So you work with the company A, and let's say you did a lottery with company A, you're working for them, and then you would like to work for the company B. Because the H-1B is tied to the employer, you cannot just work for the company B. You need a second H-1B, and that is called concurrent because you would be holding two H-1Bs at the same time. You can even have three H-1Bs or four. I have a lot of doctors that have several H-1Bs because they are working for different companies or practices.
Right.
And it's a good idea to have that concurrent H-1B, especially if it's a startup, because in case that H-1B is not successful, you're going to fall onto your original H-1B. Nothing happens to you. You can just refile that second H-1B. Or if you are thinking you are going to be, your position is going to be terminated, it's not a bad idea to have that second H-1B.
Here's a good question here. When can employers start to apply for a green card for employees? Would employees have to be on F1 OPT or H-1B application pending? So most of the time, you want to be on an H-1B visa or another non-immigrant dual intent visa for that green card sponsorship. Because depending on your country of birth, it's going to take several years. And some of these non-immigrant visas have a strict non-immigrant intent, like the F1, like the TN, E2 even. So you're not going to be able to continue to live in the US and work in the US on this other non-immigrant visa status you have if you have your green card application pending. Because the processing time for most green card applications, they're going through the PERM labor certification process. Even if the I-140 is premium process, then it's still going to take several years. So you're just, most cases, not able to get everything done. So again, but it's a very, case by case basis. If you don't have the per country backlogs, it might be possible, but we still want to put you into the H-1B lottery so that we can make sure that you are on track to be an H-1B, perhaps if it takes longer than, the 3 years if you have the STEM EAD.
This is a good question, and I think this is going to be our last. Does the sponsoring business have to demonstrate financial capability to hire someone? Not for the H-1B. So this is absolutely required for the green card, for the labor certification or PERM, but not for the H-1B. You don't have to prove that you have financial ability with the tax returns. You don't have to do that. But of course, you need to be paying the prevailing wage. Okay, so should you have any questions, feel free to email us. We are pretty flexible. We try to respond as soon as possible. If you do require in-depth consultation, feel free to reach for us as well. And as Snehal mentioned, feel free to sign up for our newsletter so you can get all the new information. There's a lot happening. Every single day, there is something new. It's even hard to keep up. So unfortunately with that, we have a lot of bad information out there. So feel free to reach out. Do not hesitate. If you need the recording, also email us. And thank you for attending. Um, have an awesome
Yeah.
day and good luck in the lottery.
Yes, thank you all.
Bye, everyone.